A little story, if you will, one of these tales from the bar, so please forgive the clickbait of Prince Harry to get you in here, but it is tangentially connected to the Prince Harry case, in that this is a story about a case that was discontinued. So we've done a couple of videos about Prince Harry discontinuing his claim, and thus he's going to have to pay the costs. Now, those costs are hundreds of thousands of pounds. The story is not quite so dramatic as that, but it is quite... it's quite a personable story to the people involved. And if you were involved, if this were you, the defendant to this claim, you'd be quite frustrated. So whilst obviously I can't give you personal details, I would never do that, but I can just give you a broad overview of what the claim is and what happened. And so in a nutshell, this defendant had a claim brought against them for, among other things, discrimination, breach of contract, and I think there was a hint of negligence in there as well. But it was principally the breach of contract, the alleged breach of contract, and the alleged discrimination, neither of which I felt really held any water. And as it turns out, we never got to hear a full adjudication on it because, as you guessed it, as the clickbaity style of this thumbnail would suggest, brought you in because this was a story about the claimant discontinuing a claim. Now, it appears to me that the claimant in that case discontinued the case because they realized it was a bit hopeless. And I suspect that they realized that because the defendant engaged lawyers and drafted documents to defend this case robustly. And at some stage, I feel that the claimant felt this wasn't going to be successful. It was going to be far too stressful. And maybe they were worried about costs as well, because as I've talked about on another video, which is going live today, not sure of the timing of this video, but it's going live today on Black Belt Barrister, about the costs implications of discontinuing a claim. Because if you discontinue a small claim, then ordinarily there are no cost consequences for that. So if you're the defendant of a small claim, there is no cost consequences for either party for the claimant to discontinue that claim. A small claim, for those international viewers or even England and Wales viewers that aren't familiar with the rules here, a claim that is purely monetary, not more than £10,000, different limits for personal injuries, but not more than £10,000 for a standard money claim is a small claim. And a small claim is designed to be slightly less formal, slightly more relaxed because it's usually just litigants in person, not engaging lawyers. So the rules are very slightly relaxed, but they still have to comply with those rules for the vast majority. When I say the rules are relaxed, there are slightly different rules that apply. Those rules themselves are not relaxed, and the other rules that they do have to comply with are not relaxed. In fact, there's been quite a few court cases to say there's no special rules for litigants in person. And so even for small claims, litigants in person, they still have to comply with the rules. But nonetheless, for a small claim that is discontinued, there are ordinarily no cost consequences, save for a reason I set out in my other video over on Black Belt Barrister, whereby one party has behaved unreasonably. Now, back to the story. This case was not going to be a small claim because of the discrimination, the alleged discrimination elements. And because of those discrimination allegations, this is much more likely going to be allocated to the fast track, but not without some fighting for that along the way. So the defendants in that case, when the claim was discontinued, as I say, the judge ruled that there's no order for costs unless an application is made within a certain number of days. Now, obviously, there was no declaration. I say obviously, it was obvious to us at that stage that the case was not yet allocated to a track, but would ultimately be more likely than not allocated to the fast track. So ordinary cost rules apply, and the fast track rules specifically apply. And so it's one little bit of a technical, strategic move that lawyers can make while a claim has not yet been allocated to a track, that you could make applications, and in theory you could ask for your costs even if it's destined for the small claims track, although there are mixed results. And so I have had judges say no chance, this was going to be allocated to the small claims track, therefore no costs, even at the application. But again, if the application is robust, you might get those costs. But again, back to the story. So this was destined for the fast track. But the judge had said no costs unless an application's made. So we obviously said, let's make an application. And the application went in, and ultimately the judge decided that this was more likely than not going to be allocated to the fast track, and so costs were payable. There were certain deductions, such as it was reduced to the hourly rate for the lawyers in that area. Interesting point here, lawyers can set their own fees, but they might be changed to what the local rate is for that court, especially if the other party is an individual against whom the order for costs is made. And so the order for costs was made. It was in the thousands of pounds, all of which for a bit of a nuisance claim, really. Not nuisance as in legal nuisance, as in the claim itself was a nuisance, because the claim itself, in my view, was never likely to succeed. And I think the claimant realised that and therefore discontinued it. But not without a lot of stress, back and forth, disrupting holidays, no doubt keeping them up at night, spending lots of money on lawyers' fees in the meantime, and then hoping that they get those fees back. Because ultimately, many individuals will simply not be able to pay those fees within the time frame required, which is typically 14 days. 28 days if the judge is being lenient or there's very good reasons for it, but typically 14 days. And so if they can't pay those fees, then there's an assessment of how much they have, what debts they have, and how long they can pay. And some of them end up paying, a few pounds a week or something like that, which is hugely unfair to the parties that have paid thousands of pounds out on lawyers to defend these claims, only for them to be discontinued. And they are down thousands of pounds, having defended what would ultimately be just a bit of a nuisance claim. So this is why many people find that the system is unfair. People say that the system doesn't work because this is allowed to happen. But whilst in one sense I would agree and say that this makes it feel very unfair, it makes the system feel very unfair, it makes the system feel old and creaky and broken. But I would challenge anyone to find an alternative, because you have two parties, one saying this happened and you should give me the money for these reasons, and the other one saying, no, I shouldn't because of these reasons. How are we to decide that? Some prospect that AI is going to decide at some point and look at all the evidence and read from witness statements and come up with conclusions. But I just feel that that is not really going to replace both, for one matter, lawyers properly and robustly representing the case and cross-examining witnesses in the witness box, and then a judge hearing all the evidence completely impartially. I mean, barristers act impartially and in an unbiased way when representing the case, but the judge is one hearing both sides, and so your job as one lawyer is to represent your side of the case and vice versa, whilst you will be hearing the other side's arguments so that you can attack those arguments. You're not sitting in an independent seat listening to both arguments. And that is what the judge does. And so this is why the system might feel hugely unfair to many. But moving back to Prince Harry. Now, he's obviously going to have costs paid to the newspaper, and they will be going for assessment, what we call detailed assessment, if they're not agreed. And they're going to be in the hundreds of thousands of pounds that the newspaper has had to pay out. So whether you like the newspapers or not, the newspapers have had to pay out these costs and now have the claim discontinued against them. So on the one hand, it might be a relief for the newspaper that they don't have to go to trial. On the other hand, the newspaper might have wanted it. In fact, my gut feeling, I'll ask Al for his gut feeling. My gut feeling is that the newspapers wanted this to go to trial so they could prove their point. They could prove that this was opinion, that they could go to trial, and if they won, they would get the judge's ruling, as they've already had a ruling from the judge in December on the application for default judgment and strikeout, the judge saying this is likely, there's a real prospect that the defendant's newspaper is going to be able to show that this is an honest opinion. And so had they actually gone to trial, they would have had a judgment to that effect, that this was just honest opinion and an honest person could have held that opinion if they're in possession of the same facts. So they may well have wanted, even though it's going to cost them hundreds of thousands of pounds in lawyers' fees, the newspaper might well have wanted the case to go to trial so they could prove that. Conversely, Prince Harry has obviously decided, for whatever the reason, we'll probably never know the real reason. It's one of a number of reasons. It's either he's fed up and just wants to give in. He might feel that he's won the other case, so he doesn't need to do this one. He might feel that this is costing too much and let's just draw a line under it. Or he might well have taken note of the judgment with assistance from his lawyers to say this is likely to fail. So who knows? Maybe we'll never know. But I thought that was just an interesting comparison and perspective, because this was a real case, much smaller numbers, but real people, real cases, having these claims brought against them for, in my view, frivolous arguments that should never have been brought. And maybe, again, we'll never know the real reasons why that claimant discontinued the claim, but maybe they discontinued it because they realized that it was just not going to succeed. Maybe they saw the strength of the arguments that were put forward in defending that claim and then realized, this is not going to succeed. So cuts the losses short. Because maybe they took legal advice and maybe they were told that it was likely to go to the fast track and therefore liable to costs if they lost the claim. But at that stage, they may well have thought that it will be on the small claims track and therefore no costs, consequences, so let's just go for it. Who knows? I don't think we'll ever truly know. But to adopt my learned friend Alan Robershaw's comments, if you did find that vaguely interesting, please do consider hitting the like button, subscribe, hit the notification bell to receive more like this. And as always, thank you for watching.